top of the heading says, the prosecutor did not engage in misconduct. Do you stand by that statement?
Yes, Your Honor. Misconduct as defined as the violation of due process by these cases. So we have both the state Supreme Court.
So you believe it only is misconduct if it affects a defendant's right to a fair trial, due process. That's the only time we should consider misconduct.
Yes, although I think we might be discussing semantics here. What we're really talking about is that the due process standard requires a defendant to show that the prosecutor does something improper, and that impropriety infected the trial by making it impossible for the jury to issue a fair and impartial verdict.
Authorities suggest that we even have, when you're discussing individual instances of misconduct, why would we even look at due process?
The authority would...
What authority suggests that?
Donnelly and Darden from the U.S. Supreme Court.
Arizona, and let's talk about Arizona law.
So Arizona law is admittedly a bit inconsistent on this question, because when Arizona authority talks about prosecutorial misconduct, almost every case opens with the due process standard. And then some of the cases talk about individual instances, but then ultimately reviews them for the cumulative standard.
And Mr. Chris, let's go back. If we take a more narrow definition of prosecutorial misconduct, okay, and we say conduct engaged by the prosecutor that violates the rules of evidence and ethics, under that definition, do you believe that your statement that the prosecutor in this case did not engage in misconduct is true?
We would argue that the prosecutor may have done some things that violated rules occasionally, and the court sustained objections when that was appropriate.
When we say occasionally, are we talking once, twice?
I don't have a number. I don't have a number for you, but I would say in a 6-month trial.
The fact that there was 39 objections sustained on argumentative questions to the defendant. 39.
39 in context of the 6-month-long trial.
Though. Not just objections made, sustained. How does that not register into the prosecutor's mind that something may be off in my questions?
Well, perhaps it should. Ultimately, the mental state of the prosecutor is not relevant to this analysis. The defense is not raising a pool claim here. It is only raising a claim of prosecutorial misconduct. And the intentionality of the prosecutor simply isn't relevant to whether the jury was prejudiced.
So if we accept your proposition, let's go on to question 11 in the questions we set out for you. What steps, if any, might a court take to constrain a prosecutor's conduct inside the courtroom during the proceedings if there is overwhelming evidence of guilt? What is a court to do if a prosecutor becomes, rather than the minister of justice and the finder of truth, and becomes an actor on a stage who is loving publicity instead of doing the job of getting to justice?
I think there are several things the court can do. The court can do what this court did and sustain objections when appropriate. The court can admonish the prosecutor. Ultimately, if the court finds that the trial is not prejudiced, but the prosecutor's conduct is out of line, it can do the same things an appellate court can do. State versus Valdez tells us exactly what this court should do in that circumstance, which is to affirm the conviction and then to refer the prosecutor to bar proceedings if that's appropriate. But what the court can't do is declare a mistrial when there's no prejudice to the jury.
Okay, so let's go to a statement made by the prosecutor at the bench on April 2nd, 2013. They're in a discussion, and the judge is there, Ms. Willamont is there, and Mr. Martinez basically insults Ms. Willamont, talking about if he were married to her, which is an inappropriate basis to object, to discuss. It also calls into account her gender, which is inappropriate, and he also used an expletive, which would, in my experience, get you expelled from most courtrooms. How do you even defend that kind of conduct in this context of a death penalty case?
I don't think that comment was appropriate in the slightest. However, the jury did not hear it, and ultimately what this court is deciding is whether the trial was fair.
So it's only about whether or not the jury hears it?
Yes.
So when a prosecutor walks up to the bench and engages in vulgarity to a judge, that's okay. That's okay, as long as he says it just loud enough that it doesn't get all the way to the jury box.
No, it's not okay at all. It's just a question of remedies, and the remedy is not to reverse the conviction. That's what every case on the subject has said. We don't punish prosecutors by reversing convictions.
So, Mr. Chris, what do we do when somebody engages in a persistent course of shenanigans that goes flying in the face of the rules of ethics and in the face of the rules of evidence? Would you agree with me that unless you have a strong basis in evidence to support an inference that one of the expert witnesses is having an inappropriate relationship with the defendant, unless you have a basis in actual fact, that inference is inappropriate and in violation of the rules?
If that's what occurred, I would agree, but that's not how I read the record.
Tell me how you read the record, because I'd like to understand.
So when he uses the word feelings, he's not referring to some kind of romantic attachment. He's referring to Dr. Samuel's discussion about compassion. And this comes from an earlier discussion where Dr. Samuels had done several things that later the state's expert was going to come up and say were inappropriate. There's a line between therapeutic treatment and evaluation.
Show us that in the record.
Show us that in the record.
Where did your people come up and say, oh, no, that was good, that was perfect?
Well, what our expert did was our expert came up later and said that an evaluator ought not to cross the line to become a therapist. And several of the things that Dr. Samuels had done were on the wrong side of that line, such as the gift of the book, such as having an extended interview session, and also the rescoring of one of the tests. And so when the prosecutor asked Dr. Samuels about it, Dr. Samuels' explanation was that he thought that Ms. Arias was suicidal, even though he never reported that to anyone, and that he felt compassion for her. And they may have quibbled over semantics about whether sorry or compassion was the right word for that. But ultimately, Dr. Samuels did say that he felt some sort of feeling that compelled him to do it, and the prosecutor thought that feeling could compromise the objectivity of his
He
conclusions.
also said it was common practice to provide self-help books that the prosecutor continued to categorize as give gifts to Miss Arias, which a self-help book when you are a psychiatrist is not the same as giving a gift in the traditional sense of what we would call a gift. Would you at least agree with that?
Not entirely, Your Honor, because again, the question isn't simply did he act as a proper psychologist, it's did he cross the line from being an evaluator to being a therapist. And that's what Dr. DeMarte talks about when she comes up for the state.
But the prosecutor insinuated it was some sort of inappropriate relationship outside of the context of, I feel sorry for you. And I've read the record, and that's the way I read the cold record. I can't imagine what it was like in the courtroom. So tell me, was that inappropriate if in fact that's the way I'm reading it?
No, in light of the U.S. Supreme Court's decision in Donnelly. Donnelly tells us that we ought not to assume that a prosecutor's comments have the most objectionable meaning if there are multiple ways to read it. And here, I think it's entirely...
Just get close to the line and not say the words that you're having a sexual relationship or you want to have a sexual relationship. You can just say a relationship, even though a juror specifically asked a question. I mean, I think that our reading of the record, counsel, is different. It's much different than theirs. So I think the question is, let's assume that it was inappropriate. That doesn't change your mind at all about whether that could qualify as prosecutorial.
Ultimately, I think we're looking at whether the jury was prejudiced. And so, assuming for the sake of argument, and I'm not conceding that that's the reading of the record because it's not how I read the record, but assuming for the sake of argument that were the only way to read the record, it would be improper without an evidentiary basis. However, I think all of the reasons why there wasn't prejudice in this case would apply. For one, the prosecutor, the trial court, made multiple findings throughout the case at various times in their objections. And then at the end of the case, that nothing the prosecutor did amounted to the sort of prejudice that would merit a mistrial.
So just let me explore that a little further. So there's probably, half a dozen times at least that motions for mistrial were made
Yes.
and denied.
Correct.
What significance does that have for us?
I think
Does that mean that the trial, are we to presume the trial court was correct every time?
we defer to the trial court's findings of facts and of the demeanor of witnesses and the prosecutor and the jury. State versus Halsey tells us that when a trial court finds that the prosecutor's actions were not prejudicial, that is meriting deference. So I think we should consider that. I think we also consider the curative instructions and the jury instructions in this case, that the lawyer's comments are not evidence and the jury should only base their decision on the evidence and not sympathy or other kinds of emotional issues. And then finally, there is the overwhelming evidence of guilt. I don't think we can look past the fact that the evidence of guilt is very strong in this case.
That's on that point. Can you cite any authority from Arizona, or you can cite other jurisdictions if you have some? What authority supports affirming conviction when there has been intentional, pervasive misconduct based on overwhelming evidence? In other words, let me explain that more carefully. When there is overwhelming evidence, what authority supports affirming the conviction when there's been intentional, pervasive misconduct in the case?
Darden versus Wainwright from the United States Supreme Court references overwhelming evidence. State versus Newell from our Supreme Court.
References it, but did it affirm? It said that the prosecutor, in fact, engaged in intensive, pervasive misconduct, but nonetheless, the court upheld the conviction. That's my question.
State versus Newell, State versus Godot, and Darden all affirm ultimately upon finding that the prosecutor engaged in improper behavior, but in light of the overwhelming evidence, they would affirm. I would, though, add that the intentionality...
Improper behavior, are you saying that improper behavior was intentional, pervasive misconduct?
Intentionality is not something we consider at the stage of the analysis.
What stage of the analysis we at?
We're at step one of pull. I mean, not because we're in a pull claim, but ultimately the question here is just, should there be reversal on prosecutorial misconduct? And the intentionality of the prosecutor is not part of that analysis.
And I understand your argument that you raised between the difference between Poole and Hughes, and that the Poole is that solely, it should be confined to a double jeopardy case. But that's not how the Supreme Court and our court have viewed it. Now, maybe we're wrong on that, but I think under existing law, we do look at intentionality.
Well, I'm not sure the law is that clear. Part of the problem is we also have, from a variety of Arizona Supreme Court cases, even as recently as Halsey, statements about how we don't reverse convictions to punish the prosecutor. The only relevant person...
I'm just asking for a case that actually finds intentional, pervasive misconduct and still affirms the conviction. I think what I'm taking for your comments is there's not one, and we would be the first to say so if we're to affirm the conviction here.
I stand on the cases I cited, State versus Godot, State versus Newell, Darden versus Wainwright, all found that overwhelming evidence was the reason to affirm in light of the prosecutor's improper conduct. But the other thing about the intentionality is if that's really the test, then pull doesn't mean anything, because every reversal for prosecutorial misconduct, assuming that all misconduct had to be intentional, would mean that double jeopardy would attach with every reversal.
In light of what opposing counsel said, is that really a concern? When she pointed to perhaps four cases in the history of Arizona that have actually reversed a conviction for prosecutorial misconduct?
Well, I'm not sure I would say it's a concern. It's just pull is binding precedent, and it has to mean something. And if the pull tests were illusory because only one of the three prongs actually did work, then I think that would suggest that that's not a correct reading of Arizona case law.
And I like that we're talking about the prong, and I'm going to go back to no prosecutorial misconduct occurred. You understand that's a two-prong, did it occur? And the second prong is, did it affect the trial? So again, you keep telling us that prosecutorial misconduct did not occur because it did not affect fundamental rights. What I'm telling you is, did prosecutorial misconduct occur? Did the prosecutor in this case engage in conduct that violated his ethical duties, his duties of candor to the court, and his professional conduct?
There were times when the prosecutor did things that would meet that definition. I would first say that the violation of ethical duties doesn't necessarily mean that he committed misconduct for purposes of the due process standard. They're actually separate tests. And also, ultimately, what matters is the prejudice of the jury. So even if the prosecutor did something improper, but it wasn't prejudicial, then it ultimately wouldn't result in reversal. So
Does it then just become an ethical problem that needs to be addressed?
Yes, Your Honor.
So that's where we're left with that?
Yes, that is what the tests say. That Halsey and Lynch and a variety of other cases are clear that we don't reverse convictions to punish prosecutors.
So going into the case, the prosecutor knows that. Because the prosecutor knows what his or her evidence is going into the case. So they have free reign, absolutely free reign in a case, because there's nothing an appellate court can do to reverse that conviction. And not that we would want to, of course not. That would be detrimental to victims, to the society, to the judicial system, but what prevents a prosecutor? What is this? What measures are we looking at to stop a prosecutor from thinking in the back of his or her mind that they can engage in this type of behavior, and no matter what happens, I'm not going to get reversed?
Disciplinary sanctions are the appropriate remedy for that. I think correct. I think it's important to keep in mind, especially in a case with overwhelming evidence, that we have a conviction, and if we think, for purposes of this question, and then of course it's also our argument, that the jury was not prejudiced, then ultimately the trial was fair. And so if the prosecutor does improper things that nonetheless result in a fair trial, then it would be a greater miscarriage of justice to reverse the conviction and let a person go free who was convicted by overwhelming and fair process.
So I want to make sure, and I'm going to pin you down on this. You agree that improper conduct was engaged in on the part of the prosecutor in this case?
There are some instances, yes. Not as many as the defense argues, and none that resulted in jury prejudice.
Can I ask, not as many I guess I'm going to say not as many acts, or not as many acts on multiple occasions. I mean, there are dozens and dozens and dozens of objections that were sustained on the same issue. How do we deal with that? Is that cumulative?
Well, if the objection is sustained, then often the answer was never given in many of these cases. And there was a jury instruction at the close of trial that the jury should not consider questions or answers that result from sustained objections. It didn't need to be the case that the court struck an answer, because the jury instruction actually covered both question and answer. We presume juries followed those instructions. And so, especially in the case of sustained objections, I think we have more confidence that we wouldn't have prejudice.
Let's move on to the next topic because we're going to run out of time here. When we talk about publicity inside and outside the courtroom, the prosecutor maintained that anything that happened outside the courtroom was not, in fact, misconduct. And based on the definition I've given you of misconduct, do you agree or disagree with this statement?
I disagree with that. The ethics rules are clear, actually, that the prosecutor has certain ethical obligations outside the courtroom to not make prejudicial statements to the media, and the trial court certainly could enforce those rules and admonish the prosecutor if he did something out of line. Ultimately, in this case, though, that didn't occur. The worst that the defense cites here is the prosecutor takes some photos and signs some autographs with people. I'm not even sure if those violate the ethical rules, and more importantly, the trial court held an evidentiary hearing on the question, took witness testimony, and concluded the jurors knew nothing about it. So really, in the end, it didn't contribute to any kind of prejudice for either the prosecutorial misconduct analysis or the Shepard trial publicity analysis.
So let's talk about the publicity and the fact that there was a request for sequestration. It was denied. There was at one point a request to remove the cameras from the courtroom. The publicity in this case, from whatever source, led to defense witnesses being threatened, and it's death threats, quite frankly. Counsel for the defendant being threatened. To work in that kind of a environment where not only are you worried that you're doing a good job, you're also worried for your own physical safety. What can a court do at this point?
What could the court? Well, the court could have. I think the real ultimate question here is much like the prosecutorial misconduct question: was the jury affected? And so while these things are unfortunate, they're certainly not things that anyone wants to have happen. They're not a basis for reversal.
So death threats. We should advise in certain cases that your life may be threatened and there's really nothing we can do about that. So what, just suck it up?
I think that the court could try to order more protection for someone perhaps, but at the end of the day, the court can't control everyone outside of its chambers. And while we certainly are not approving or supporting anything of that sort, but it's just not relevant to the Shepard analysis, because what we're looking at the end of the day is whether we can rely on the jury to give a fair and impartial verdict. And these things the defense has not linked them in any way to the jury's deliberation. So
the Shepard analysis just simply doesn't fit this situation.
Well, there is no case that does, and that's, again, authority for affirmance here. Ultimately, the defense bears the burden, much like a prosecutorial misconduct analysis where the defense has the burden to show both impropriety and prejudice. We don't presume prejudice in that context. Here, the defense has the burden to show that trial publicity was so pervasive that we simply just can't believe the jurors' answers when they tell us they're not considering it. That's not what happened here. If you actually look at the very few, and I should add, Arizona's never reversed a case on this so far as I can find, and the U.S. Supreme Court hasn't done so in over 50 years. So if you go back to the very small handful of cases where the U.S. Supreme Court has actually reversed on a trial publicity claim, the order of magnitude of the coverage and the inflammatory nature and inaccurate nature was so much worse than anything that occurred here. So Shepard, for instance, you have a judge who refuses to admonish the jury to not consider these things. And you also have inflammatory accounts of perhaps the defendant is having an illicit affair with an inmate, the presumption of guilt, all sorts of things going on, and that's just not present in this case.
So, from the state's perspective, did the court do anything, or could the court have done anything differently that would have reined in the carnival-like atmosphere that's alleged by your opponent?
I'm not sure what more the court could have done, really. The court could have admonished people in the courtroom, but ultimately the courtroom itself is fairly serene. Most of what the defendant argues about here is conduct by third parties from the internet and other places after the trial is concluded for the day, and those people aren't in any place where the court can do much about them.
But how was that all enhanced by autograph sessions and personal photograph sessions and all of the let's go out and mix with the public, because after all, anything I do outside is not misconduct?
Not much, I think. For one, there was no banging the drum going on out there? There was no saying, I'm one of you? No, there was one instance where he took photos and signed autographs, and we don't have any more than the record than that. And the defense hasn't really linked that up to anything that the unfortunate spectators have done in this case to threaten. Certainly, the prosecutor never called for anyone to threaten or intimidate witnesses. There's no instance of any kind of intentionality in that part. But I think at the end of the day, really what we're coming back to is, was the jury affected by this? The court polled the jury over 20 times, and I don't think that militates against our position. That supports our position. I don't think courts can be put into a no-win scenario where if they poll the jury too many times and that shows that something must be wrong. A few things the court did do here, providing security, polling the jury, the defense uses these to argue that meant there was more prejudice. Well, if that's the case, then there really is nothing a court can do, and a high-profile defendant becomes untriable if the media attention picks up too much. And that certainly can't be the law either. If the court has no further questions, the state respectfully requests it affirms the conviction and sentence. Thank you.
Thank you, Mr.
Your Honor, first I would like to address the court asked a question about whether remedy is required for intentional and pervasive misconduct, and that's actually a holding in minute, almost word for word the holding in minute, that intentional pervasive misconduct that affects the structural integrity of a trial requires a remedy, and not only a remedy but a double jeopardy bar to retrial. And I would like to point out we are making a pool claim. We argued the cases regarding double jeopardy, the standard for when double jeopardy is met, and we argued the facts in our case that meet that standard, which includes the element of intentionality. Intentionality is important not only for a double jeopardy claim, but also for a due process claim. In the cases where the courts decide that there isn't misconduct, even on that end of the spectrum of misconduct, what you see the court saying is, this isn't misconduct, it was merely negligence. It was an isolated loss of temper. So they're using intentionality on either end. So it is that in as much as non-errors and harmless errors help us show that the prosecutor acted intentionally and with an indifference to the danger of causing a mistrial, those errors are counted. And so Hughes itself, the case on cumulative error, explains that you do consider intentionality. I'd also like to address the idea that we ought not assume the worst possible meaning of a particular phrase used by a prosecutor during the trial. A phrase or a question, or when you're looking at whether or not the prosecutor says something and is that thing really is we have two different directions we can go with it. One of them is fairly innocent and one of them is pretty terrible. Should we assume the more innocent version or the terrible version? And my opposing counsel noted that we shouldn't assume the worst meaning. And Hughes actually stands